Hey everybody, want to talk about some laws? Good, you're in the right spot, because today we're going to talk about some laws. Particularly, we're going to talk about a couple of important concepts to highlight from the chapter that have to do with mass communication law and what we are allowed to say and when we're allowed to say it. And hopefully we can think about a little of the rationalization that goes in to why we have these laws to start with. Okay, first of all, just as a warning before we get going here, one of the important caveats that I feel like it's always my duty to say when we go to talk about law stuff is that I am not a legal expert. I do not have a degree in law, despite having studied a little bit of it. I am by no means a legal expert, and so please don't go get yourself in trouble and say, but Dr. Riley told me I could do this. Just be careful. Also, this is a very simple cursory glance at some very otherwise deep stuff. So we're taking a very simple look at this. So don't take this as a, like, now I know everything about libel law sort of approach to it. That is not coronavirus. I just have allergies. Okay. An important note here, all of this falls under the First Amendment to the Constitution of the United States, which I bet you remember from your government courses or in your gen ed side of things or from high school. But just as a reminder, it says Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press or of the right of the people to peaceably assemble and to petition the government for a redress of grievances. What a wonderful, wonderful little paragraph it is. The part that we're going to focus on specifically when we talk about mass communication law is the press. So what exactly counts as the press nowadays anyway, as weird as that is as a phrase? When we think about and we talk about freedom of the press as a concept, what we are saying by the press is, quote, every sort of publication which affords a vehicle of information and opinion. And so when we talk about freedom of the press, we are talking about the notion of publication or the notion of distribution through mass communication. So what does that mean? Does it mean that you can just go out and say anything you want and publish anything you want? And say anything you want over the radio or the television without getting any trouble? And the answer is not quite. Like, there are rules in place here. The Supreme Court has decided on a number of court cases that do limit free speech. And some of those cases can impact you. And it's important to note that almost all of these limitations to free speech and limitations to freedom of the press have come in the form of Supreme Court decisions. So a really basic Supreme Court case for this kind of stuff would be the case of Brandenburg v. Ohio. And I'll let you read the details of the case. We're not going to get into that level of it and this sort of cursory overlook. Instead, we're just going to quickly sum it up as the finding of this case said that the government cannot punish inflammatory speech unless that speech is directed to inciting and is likely to incite imminent lawless action. Now, how you actually define imminent lawless action is way more complicated. That'll require a little more specificity. So the first big area of freedom of the press is called something called prior restraint. And it's something I want to emphasize here early on. Prior restraint is the question. Can the government stop you from publishing something in the first place? So if the government doesn't like something that you were going to put in a newspaper or put on a website or record yourself saying and put on a YouTube video, can they stop you from doing it before you do it to begin with? And the answer is not really, but it depends. And this is going to be one of those situations where like the whole idea of talking about law stuff is going to have a lot of but it depends in it. And so, just keep that in mind, and we'll go over some of those. But law is almost never purely this or that. There's a lot of ways in which there are nuances of interpretation. Also, big shout out, I figured out how to do the highlighting thing over these recorded PowerPoints, which is pretty cool. Now you guys can't stop me from doing that. So there's two big cases to consider when we're talking about prior restraint. The first is a court case called Neer v. Minnesota. In Neer v. Minnesota, the context for it was there was a guy who was a newspaper publisher of a newspaper in Minnesota. His name was Neer, and he was a jerk. He was a racist and an anti-Semite. He hated Catholics. He was just all around kind of a jerk. And he published a newspaper that was also kind of not great. Had a lot of racist stuff in it, was very inflammatory. And so the state of Minnesota stepped in and said, hey, you're not allowed to publish this anymore. It is inciting people. And so the court had to decide, well, can the state of Minnesota stop a newspaper publisher from publishing his or her newspaper? And they found that a Minnesota law that imposed permanent injunctions against a publication of newspapers with, quote, malicious, scandalous, and defamatory content violated the First Amendment as applied to the states by the 14th. Minnesota Supreme Court reversed. Okay, so what essentially the court decided here is that state governments cannot stop you from publishing something without violating the Constitution and your rights unless what you are going to publish, one, jeopardizes national security during wartime. Two, it is legally defined as obscenity, which I am not going to go into defining obscenity for you. You will learn that in your mass comm law specific courses. And three, if it incites violence and or the violent overthrow of the government. Okay, so we've established that the states and state governments cannot stop you from publishing something. Does that mean the federal government can stop you from publishing something? Unfortunately, that would go unanswered until 1971, when there's a fella named Daniel Ellsberg. There's a picture of Ellsberg there. And Daniel Ellsberg, while he was doing some work for the Rand Corporation, found a report called The United States-Vietnam Relations 1945 to 1967, a study prepared by the Department of Defense. Essentially, it was a study that showed that the Vietnam War was unwinnable and that the United States was never going to get what it wanted out of this whole conflict. It was much better off just sort of leaving. The downside is that this was discovered in the early 60s, and the United States kept sending more and more troops to Vietnam. The death toll increasingly got higher and higher. And so in the 70s, as the pushback against the Vietnam was getting more and more intense, there was a feeling from some folks who had managed to get a hold of this report that the government on both sides, Democrat and Republican, had been unnecessarily keeping this war going for no real good reason. So Ellsberg gives copies of the newspaper, or gives copies of the publication to a bunch of newspapers, and the New York Times decides that they are going to publish this report that is otherwise known as the Pentagon Papers. The government tried to stop the New York Times from publishing these papers, and it went to the Supreme Court in a case called the New York Times v. the United States. And the Supreme Court decided that the federal government cannot stop you from publishing something without violating the Constitution unless, ... Notice we have a lot of these unlesses when we're talking about law. Unless the government can prove that publishing the given content would cause grave and irreparable danger. Now, the problem has been that the courts didn't really define what grave and irreparable danger means. And so smaller courts in the United States have sort of been up to them to decide that. And other patchwork findings and pieces of regulation, none of which have really given us a purely definitive term for definition for what grave and irreparable danger means. So the history of all of this is pretty much that the decision to do this, to both steal the report and to give it to newspapers, and then newspapers' decision to publish it, would very much anger then President Richard Nixon, who, among other things, ordered people to break into Daniel Ellsberg's psychiatrist's office and break into his filing cabinet and try to find incriminating evidence on Daniel Ellsberg, which they never really found. Another one of those fun things that we get to remember in history as something Richard Nixon did. And all of this, this drama with the decision to publish the Pentagon Papers, if you're interested in that as a story topic, there was a movie that came out a couple years ago starring Tom Hanks and Meryl Streep called The Post. This movie has to do with the Washington Post decision to publish parts of the Pentagon Papers after the New York Times was told that they were not allowed to do it while the lawsuit was going on. It's a pretty good movie. It could be better, but it was pretty good. And it turns out that the courts almost never decide in favor of prior restraint outright. There's always exceptions. It's always, you can't prior restrain, but you can in these very small instances. That is, unless you're a high school student, in which case a whole nother set of court cases have determined your fate and your rights to free speech. That is the hot take assignment for this week, by the way. I ask you to take a look at the Hazelwood v. Kuhlmeyer case and tell me what you think of it. I'm not going to go into it on this lecture because I want you to look it up in order to teach yourself about it to be able to answer the hot take. Okay, so just as a warning here, as we are talking about prior restraint and as we lead into some of the other conversations, just because the government cannot stop you from publishing something does not mean that you won't get in trouble for it once it runs. That's a very big difference to remember here. Prior restraint is only if the government can stop you from publishing it to start with. It has nothing to do with if you'll get in trouble for publishing it once it is published. Once you publish something, you still have three big areas in mass communication law to deal with. One of them is libel, one of them is privacy, and one of them is copyright. And we shall go through them now. The first one, and I think the scariest one to deal with, at least personally coming from a former reporter who worked in journalism, is libel. And in order to make libel scarier, I've sort of decided to drip blood off the top of the PowerPoint here. Isn't that a cool effect? Okay. Libel is, quote, a punished false statement that is damaging to a person's reputation or a written defamation. And there is an important key word there in the definition, and that key word is false. The easiest way to defend yourself against someone claiming that you libeled them is making sure that what you have said is the truth. It has to be false in order to be libel. If it is true, it doesn't matter how bad it makes somebody look. If it's true, it cannot be libel. Another important point here is that these are civil cases we're talking about when one person is suing another person. So the kinds of evidence you present are going to be different. These are not criminal, these are civil cases. And here's how you prove libel. Let's say you think someone has libeled you, for example. Step one is you have to show if the person is a public official, a public figure, or a private figure. These are different things. Now, a private figure is everyday people. That is someone like you or me. It's just somebody who is not known for anything otherwise than just being a regular person. If it's a private person, there's a much lower burden of proof that you have to present in order to win a libel case. You must show that the information that was published was false, and that the publication that decided to publish it was careless or negligent in the act of publishing it. We can sort of sum that up by saying that they didn't exercise reasonable care while performing the duties of a journalist. But remember, it still has to be proven false. Now, that's the easy way. If you're a private person, it's very easy. If you're a public person, it's much harder to win a libel case. If you're a public official, that means you're an elected person or someone who has been appointed into a government position. It's somebody who is meant to be a sort of civic guardian of sorts. A public figure is somebody who is simply in the public spotlight. So Bill Gates, for example, is not in any government office. Bill Gates is not an elected official, but Bill Gates would be considered a public figure because he's in the news, he's very wealthy, he's a prominent business owner of a very large business, so he would be considered a public figure. These can also be what we call pervasive or vortex public figures. Those are folks who are not otherwise public figures and normally are private, but have done something to elevate their stature into the public figure. So let's say there is a protest going on, and somebody in the protest lights off a bunch of firecrackers and chucks them at City Hall, and it causes everything to go kind of crazy for a couple minutes, and that person gets arrested. That person we would consider a public figure because their actions elevated them into the stratosphere of the public level instead of the private level. because people are paying attention to them now. The difference between private and public is largely about your access to attention, your access to defend yourself. If you're a public official or a public figure, the assumption under the law is that you have an easier time defending yourself against accusations than someone who's just a regular old person, a regular old private figure. And that means that if it's public, if you are a person who is a public figure, you are going to have a higher burden of proof to try to win a libel case. The reason why it's harder to sue for libel is, if you're a public figure, is because in theory it's easier for you to defend yourself. I just said that. I got it too ahead of the slides. I got to slow down a little bit. I'm going to take a second and take a sip of water. Much better. Okay. So you must be able to prove that all of the following three criteria are there in order to win a libel case if you are public or a public figure. One, again, you have to prove the information was false. Two, you have to prove that you suffered due to the false information. And three, you have to be able to show that the publication that published the false information that harmed you acted in what we call actual malice. And actual malice is the idea that you publish something that you knew was false, or publish something without checking if it was false. So the quick legal meaning is knowledge of or reckless disregard of falsity. And remember, if you are defending yourself against an accusation of libel, the best form of defense is saying that what you wrote was true. Also, if you're defending yourself, you have a thing called qualified privilege, which means that reporting on official documents in a fair and accurate manner means that usually you're protected from libel. So let's say you're a newspaper reporter and you hear that the mayor of the town was arrested. And so you go get a copy of the arrest report, and the arrest report in it has information from the police officer that arrested the mayor. And you take information from that police report and you use it in the news article that you write as a journalist, and you post it to the website for that newspaper. If it turns out down the road that the police officer who arrested the mayor had a grudge against the mayor and made all that stuff up, you as the journalist are not held responsible for that, because you were doing the best diligent job you could as a reporter to trust that information to turn it into a story. Three would be fair comment. That means that you can't get sued for libel over a review or an editorial. So if there's a new album that comes out and you write a review and you just say how much you hate it and you think it's a terrible album, the artist who made that album can't sue you for libel. You're allowed to say you don't like things. And although this isn't something we're going to get into, satire is protected speech. So the idea of satirizing or trying to be funny and humorous in particularly political things, sort of poking fun at intentional exaggerations, you can't get sued for satire. Satire is protected. All right, privacy. Moving on to our next big issue beyond just libel. So believe it or not, there is actually no constitutional protection for privacy. You've probably been told that before in your life, but if you haven't, congratulations. I just told you. And that's because back when we were making the Constitution in the United States, there really wasn't much of a need to write anything about privacy in it. People tended to live in houses far away from each other. There was no electricity in order to have phones, to have wiretaps. The idea of privacy was sort of not really seen much until technology got in the way. We've had to sort of hodgepodge a bunch of smaller laws protecting aspects of privacy together, because we don't have one thing in the Constitution we can point to and say, there's where our privacy is protected. We've had to glue a bunch of smaller laws together. And so the four legal aspects of privacy and how they interact with media and mass media are intrusion, public disclosure of private facts, false light, and misappropriation. Now, intrusion would be something like reporters can't trespass on private property, eavesdrop on people, they can't bug your phone, especially when there's a reasonable expectation of privacy. And so something like if you are at an ATM, for example, a reporter can't stand behind you with a camera filming you as you type in your PIN number into the ATM. Recording without permission changes based on the states to know your laws. I can tell you that Georgia is what we call a two-party consent law, which means in the state of Georgia, or no, wait, it's the other way around. Georgia is a one-party consent law, meaning that technically, legally, you don't have to ask someone's permission to record their audio. However, ethically, you really should. But ethics are next week. Also, the truth is not a defense. There was a case back in the day where Food Lion, which used to be a popular grocery store brand, and I don't know if Food Lion's still around or not. I'll have to look that up. A television show on ABC had reporters go undercover in Food Lion stores and record a lot of really gross stuff that was going on by the employees under the direction of management. It wasn't really the employee's fault. That stuff like changing expiration dates on milk and like flipping meat over that had kind of turned green a little bit in the packaging, that kind of stuff. And then they aired it on TV, and Food Lion sued and said that essentially the reporters had been trespassing. And even though the stuff in the video was entirely accurate, they still lost the case, and Food Lion ended up winning that case because of the idea of privacy, that Food Lion was saying that their property is private. If you want to read more about that case, feel free. I'm not going to go super in-depth with it because, again, you'll hear more about it when you take a law-specific course. Number two, involving this idea of privacy, is public disclosure. This is publishing private information such as medical info, grades from school, anything not obtained via public record. And again, the truth is not a defense. So a lot of this stuff falls under federal privacy laws like FERPA and HIPAA that protect your grades and your health information at the national level. False light, which is portraying someone in a defamatory or damaging way without context. So one of the most easy to understand examples for false light would be if you were doing a story about, for example, teenage pregnancy rates. And if you were to then run a photograph of someone with that story, the assumption would then be that the person in that photograph is a teenager who is pregnant. If that person is not a teenager who is pregnant, they can absolutely sue you for false light because of how you have made them look in that by connecting that image with the story. And then misappropriation, which is making money off of somebody's likeness without their permission. And the idea of likeness is sort of a funny thing. Like back in the day, Vanna White, the person on the game show Wheel of Fortune, actually sued Samsung because Samsung tried to make a series of advertisements where a robot wearing a wig and a dress turned the letters around on a board that looked an awful lot like Wheel of Fortune, and Vanna White said, hey, that robot's just me. And so she sued Samsung and ended up winning that case. And last but certainly not least is the idea of copyright. Copyright is intellectual property rights. The moment that something is created in a permanent form, it is copyrighted by the creator. And for a long time, copyright made a lot of sense. The idea of copyright was to encourage people to be more creative and put their creative ideas out into the world, with the idea they didn't have to worry about somebody stealing it from them because it was protected. If they made it and put it out in the world, then they own it for a certain period of time. Then the internet happened, and the internet made it real easy to steal things. It made it really easy to violate copyright. Especially stuff like music and movies. We saw Napster was really the first one, followed by sites like Kazaa and LimeWire, followed by torrenting and the idea of torrenting through places like BitTorrent. The internet has made it so easy to take things and to violate copyright that laws sort of had to catch up with themselves to make sense. The issue is that everything has sort of gone beyond just stealing music and movies. At this point, you can get in trouble for stealing images, text, video clips. Violations for copyright theft online can be up to $8,000 per images, just still images, unless you have fair use. Now, fair use is the sort of exemption to copyright. Fair use is the idea that depending on the purpose, the nature, the amount, and the effect of how much you're using of a copyrighted thing, you're able to use it fairly without having to pay the copyright owner. What purpose means is what reason are you using it? Is it for educational purposes or commercial? So the rough rule is I am allowed to give students roughly 10% of a given textbook for free without having to pay for the copyright use of it. If I took 10% of somebody's book and tried to sell it to somebody, that would be a violation of copyright because I'm making money off of it. But if I take 10% of a book or one chapter out of a book and I give that to students, that's considered fair use because I'm not making money off of it. I'm using it for educational purposes. Nature is what kind of content is it? Is it historical or is it fiction? Is it an instructional part of a textbook, or is it the latest album from an artist I happen to really like? So what is the nature of the content itself? Things that are more informational or educational tend to be a little bit more on the fair use side. The amount being used, so I brought up that 10% thing a second ago. Amount plays into it. So what proportion of the overall thing are we using? Is it an 8-second clip out of a single song? Is it a 10-minute scene out of an entire movie? What is it? How much are you using? And then finally, effect, which is how will it impact the owner of the copyright? So will using something or using a small portion of something, will it lead to fewer sales and less money to the copyright owner? And if the less likely it is to impact the money side of things, the more likely you are to be able to say, hey, effects-wise, this was fair use. Now, some things are actually made from the get-go to be fair use. So some people in the last few years, few years, 20 years or so, we've seen the growth of what we call Creative Commons, which are pictures, music, books, it could be anything really, that is made and the owner has decided, hey, I know I have the copyright for this, but I am declaring anyone who wants to use this can use this. Anytime you see the little CC logo circled with something, that means it is Creative Commons. And you'll also see other symbols that go along with it that sort of limit how you can use something in Creative Commons. So it may be that, hey, this is free and open to everybody, but you can't resell it to somebody else. Or this is free and open to everybody, but you need to make sure you put the author's information with it so that everyone knows who actually made it. Now we currently have a thing called public domain. Public domain means something has existed long enough that we now say the public owns this. The original copyright owner no longer owns this, the public owns it. And we usually classify two different things as public domain. One is stuff that you cannot copyright to start with, like you can't copyright, someone couldn't come along and try to copyright the color blue or the English language, right? Stuff that you just really cannot copyright at all. Or stuff that has what we call aged out. That's what I was saying, if it exists long enough, it ages out into the public domain. And in the United States, any work published before January 1st, 1923, anywhere in the world is considered public domain. It's why if you go into a bookstore sometimes, you'll see a row of books that are classic novels that are written before 1923 that you can buy for like $1 or $2. Those are public domain works where the publisher of the book is only charging enough money to cover the cost of putting the ink on paper and sending it out to stores. This is the reason some of those older books are so much cheaper. Works originally published in the United States after 2002 have a different set of laws. They're protected until 70 years after the original author or content creator's death. And we keep having these new additions, right? We keep having these situations where to try to explain public domain is really difficult because it depends on when the thing was created, what kind of thing it is, how long the author has been dead, if the author bequeathed the ownership for a certain period of time. It is really, really difficult. And the date keeps, the reason why these laws keep changing and the reason why the date keeps getting pushed up for public domain, especially as we see it get extended out farther from the author or creator's death. And the reason why it's so complicated throughout the years, namely in 1976 and 1998, is all because of one company, and that company is Disney. And the reason why Disney keeps lobbying the government to change public domain is because Disney very badly does not want Mickey Mouse to enter the public domain. They really don't want everybody to have access to Mickey Mouse. They want to be the only ones who control Mickey Mouse, because Mickey Mouse is very important to their branding. Now, the problem is that Mickey Mouse was created in 1928, which means that Mickey Mouse is about to come up on another deadline. Mickey Mouse, actually technically the creation of the cartoon Steamboat Willie, its copyright runs 95 years since the original publication and is currently set to expire at the end of 2023. So we're going to see if in 2023, if Disney manages to get copyright law changed again to further extend public domain, or if finally Mickey Mouse becomes public domain. We don't know. And a lot of people have sort of pointed to the way that Disney has been so protective of public domain being a little bit hypocritical, because Disney has made lots and lots and lots of money off of movies that are based on stories that are in the public domain. So for example, Alice in Wonderland, which is a public domain story written by Lewis Carroll in 1865, they've made a little over $1 billion with a B dollars off of that story, even though it cost them nothing to secure the copyrights to the story because it's a public domain story. So it is really interesting to see just how much money they've made off the public domain for them to then turn around and say, well, we want to protect Mickey Mouse. We don't want Mickey Mouse to go into the public domain. So with that, that is just a very, very cursory look at some legal terms involving the mass communication and law overlap. If you are confused by any of this stuff, please let me know. And please don't forget to take the hot take, or do the hot take this week, which is all about the Hazelwood v. Kuhlmeyer Supreme Court case. So with that, I will see y'all later. Be safe out there.